sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that, place you on probation for 10 years. You're ordered to follow all of the rules and conditions of probation. That it will include entering and successfully completing the safety program. Morning. You are Aaron Wars. Feeling better this week, Mr. Wars? So, Mr. Wars, this is cause number 25 DCCR 1253. Previously, you were in court, entered a plea of guilty to driving while intoxicated, third or more, received that pre-sentence report and reviewed it. Have you both had an opportunity to review that report?
Yes, Judge. Yes, Your Honor.
In addition to that, we received an we received an update, also a memo from probation, I believe it was yesterday or late last week, and you both had an opportunity to review that as well.
Yes, Judge. Yes, Your Honor.
And so, any other issues, Mr. Smith? Obviously, based on the issues last week with Mr. Wars testing positive, there's clearly a need for some intensive treatment. Any reason though not to go along with the agreement still?
No, Judge, I think we would amend it because we did not have treatment involved. We would ask for safety placement.
Your Honor, I've gone over with Mr. Wars and he agrees that he needs safety.
Okay. So Mr. Wars, we're going to give you this opportunity today and I hope you take advantage of it. Because if you don't, things could be a whole lot worse. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, in accordance with your agreement, find you guilty of driving while intoxicated, third or more, sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that, place you on probation for 10 years. You're ordered to follow all of the rules and conditions of probation. That it will include entering and successfully completing the safety program. And then when you're out, you're going to enter and successfully complete the JCDI program as your aftercare. That will give you a longer period of time with more structure and drug tests and classes and things like that. You're also ordered to serve that 10 days upfront time. It's required by law. You'll be able to serve that while you're waiting to get taken to safety. And then any of the other conditions that probation feels like are necessary. You follow all of these and do everything that you're supposed to. This is a great opportunity because you'll be able to serve this 10-year sentence while you're out on probation instead of in prison. But the other side of that is if you violate any condition of probation, you can be brought back into court and you would be facing that 10-year sentence that you've already agreed to. Do you understand?
Okay.
I don't see the certification attached to this one. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Macon. Good morning, sir. You Bradford Josie?
Yes, ma'am.
And Mr. Wilkerson, will your client waive the formal reading of the motion?
Yes, Your Honor.
Mr. Josie, the best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And in cause number 25, DCCR 1062, I have a motion to revoke your community supervision. Shows that you were placed on probation October 14th of 2025 for the state jail felony offense of burglary of a building. And that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of evading arrest, a Class A misdemeanor, February 22nd of 2026 in Jefferson County. And is that true or not true?
That's true.
Count 2, bless you. Are we changing? Are we,
I'm playing not true to first and second.
okay?
I'm sorry, I didn't understand.
Count 2 alleges that you committed the offense of burglary of a vehicle March 9th of 2026 in Jefferson County, Texas. And is that true or not true?
Gotcha.
Count 3 alleges that you failed to report to the probation office as directed November 18th and December 11th of 2025, and then January 6th of 2026. And is that true or not true?
True.
Count 4 alleges that you failed to report to the probation office for your administrative hearing on February 12th of 2026. And is that true or not true?
It's true.
Count 5 alleges that you failed to immediately report to the probation officer your change of address. And is that true or not true?
That's true.
Count 6 alleges that you failed to provide verification of performing the community service hours as required. And is that true or not true?
That's true.
Count 7 alleges that you were at a location other than your residence at approximately 3:25 a.m. on March 9th of 2026. And is that true or not true?
That's true.
Count 8 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
That's true.
And then count 9 alleges that as of February 12th of 2026, you were $700 behind in your court assessed fees. Is that true or not true?
Yes, ma'am, it's true.
Did you enter your pleas of true to counts 3 through 9 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes.
Now, I don't want to get into, I'm not asking any questions, but with regard to counts 1 and 2, I do want to make everyone aware that if we come here and there's a hearing and you act, I don't want us to have to come and have a hearing, have officers come, if in fact there's something that is blatantly true. It's not going to help you if you're not taking responsibility.
Yes.
If you actually didn't do it, that's fine. That's what the hearing's for. But just to not take responsibility doesn't sit well. Does that make sense?
Yes, ma'am.
All right. So are we good with what we played on then?
Yes, ma'am.
Okay. Then I'm going to find that you entered your pleas of true to counts 3 through 9 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I am going to reset your case for a hearing so that the state can bring witnesses with regard to counts 1 and 2. We'll get an updated pre-sentence report done. And I'm guessing
Not long, Judge.
not long, so maybe even on 11 o'clock.
Yes, ma'am.
Okay, so we'll set it on a regular docket date, but at 11, so we can have any witnesses. Anything that you think is important for me to know, get that information to Mr. Wilkerson. He'll present it to me on your behalf when we come back.
And just for the court's information, Judge, once we have those underlying issues dealt with down the hall, then those pleas will change. So it's I'm just giving you a heads up, because if we set it for a hearing right now today and we're able to get those dealt with beforehand, then we're subpoenaing witnesses when a hearing wouldn't be.
Well, that's why I'm saying I don't want to do that. So if they're true, they're true. I don't want to, I mean, if you need time to take care of something, that's one thing, but to stand and swear under oath that something's true or not true is putting Mr. Josie in a position of, I don't know what you mean by taking care of them, but if he's going to go plea on some cases down the hall and he just said under oath that it's not true, then we have an issue.
I would like to establish on my square of
Hold on. I want you to talk to Mr. Wilkerson. Let's figure out the timing of all this, because I don't, so, I don't want him to have to subpoena witnesses. I don't want to get close and then we keep doing this and we show up and then there's some deal that's made and we've got officers who either just got off a night or whatever that had no reason to have to be here. So I've taken the pleas. I'm going to reset it at this point for a sentencing hearing. However, I want to know within at least a week before that hearing, if I want Mr. Coleman to know if he has to get those witnesses here.
Yeah.
So at least 7 days. Okay, all right.
Yes, ma'am.
And this, we've got two cases, 21-37340 and 21-37341. Both of those cases, Mr. Hebert is on probation and motions to revoke those probations have been filed. And what is the announcement?
Judge, if I may, he has a new DWI third. I've spoken with this officer, Ms. Tain, about that. I checked last week. It had not been received. Mr. Nichols was kind enough to check again this morning. The blood test results are in progress, or whatever that means. So I would ask the court if we could either go through the motion, see what pleas he will enter or hold for maybe 30 days just to allow that new case to come in. We had discussed safety as a possible resolution to pose to the court. Obviously, he can go with the new case outstanding. Obviously, the new case I will not dismiss, and obviously the court would want to see the new offense before you would determine if safety would even be an equitable option. So that's kind of where we are. Whatever you want to do, either go through it or reset it, and we'll stay on top of that new offense for March.
Oh, that's the agreement with the defense, yeah.
I mean, I don't guess it mattered. At some point, he'll have to enter pleas of true or not true. If y'all want to go ahead and do that, and then we can reset it.
I mean, that would help me expedite that case, but I don't want to put him in a position where he pleads true to it and doesn't get safety and thinks I've.
Well, that's gonna be, and I mean, if you're on probation for driving while intoxicated, third, and there's another one, I don't want there to be any thought that I will for sure go along with something like that. It's gonna take me looking at, I have no idea right now, but that just off the top of my head sounds like a big no, but I'll, obviously see the new case and look at what's been going on in this probation. I just, I don't want I don't think an agreement right now to that.
Your Honor, I understand that. I've spoken with the prosecutor. I've explained to Mr. Hebert the position that we're in, and that's not a part of the understanding that there's any
Right.
Agree.
No agreement.
agreement.
No agreement. So it's just what you guys obviously
it was
would
just
recommend. Sure. So do we want to go through the motion today then?
We can,
Or,
I'd rather have which one would expedite
A plea would, because I could push it through without the lap, but if in all candor, if everybody wants all the information, just let me make a call and ask them to move it along.
all right, we'll just
Let's do
reset. I'll
that.
just do a normal reset.
Thank you,
See
honey.
if y'all can get that taken care of.
yes,
All
ma'am.
right, and go back with the bailiff. Good morning. Are you Isis Martin?
Yes, ma'am.
And Mr. Parker, will your client waive the formal reading of the indictment?
Well, Your Honor.
Ms. Martin, in clause number 25, DCCR 1827, you're charged with the second-degree felony offense of robbery, and that's from October 14th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you?
Yes, ma'am.
You have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Martin's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. Mr. Smith, what is the state's position with regard to a bond reduction based on the nature of the
No.
plea?
Yes, Mr.
I'm sorry?
Should
There's no criminal history. This is only arrest.
All right, so you don't have any objection to it? So, Ms. Martin, what I'm going to do between now and sentencing is reduce your bond to $1,000, and I'm going to make that a personal bond. So that means you don't have to pay any money. You're just going to get out of jail. But there's some very important things about that, okay? The first is that if you don't show up for court, then they can come after you for that $1,000. But that's probably going to be the least of your worries if you don't show up for court. If you don't show up for court, you run the risk of me not accepting the plea agreement, and things could obviously be much worse. The first thing you do when you're released from custody is go to the probation department. You're going to get some paperwork today from probation. It tells you where to go so that they can start that process to get that pre-sentence report done. If you don't go to straight there, you also run the risk of me not accepting the plea agreement. Do you understand that as well?
Yes, ma'am.
And then also a condition of your bond is that you have absolutely no contact or communication with Harmony Bodner. That obviously means in person, but it means any other way as well. So you can't send messages through other people. You can't send messages on your phone, by text or Snapchat or whatever else exists out there. Do you understand?
Yes, ma'am.
Do y'all live anywhere close to each other? Okay, so there's no reason for you to have any contact with her. So you need to show me between now and when you come back that you can do everything you're supposed to, so I don't have any issues with putting you on that probation, okay?
Yes, ma'am.
All right, we'll see you back at sentencing.